Today, we're diving into a case that's right at the intersection of mind-bending technology and our most basic human rights. We're talking about the artificial witness.
So, let's just jump right in. Picture this. You are on trial, and the prosecution's star witness, the one whose testimony could literally change your life forever, isn't a person. It has no face, no voice, no memory you can poke holes in. It's an algorithm. What do you even do?
Take a look at this number. That's 170 quintillion. I mean, it's 170 with 18 zeros after it. Now, this isn't some far-off astronomical number. It's the odds an AI program came up with. It said it was 170 quintillion times more likely that a DNA sample belonged to a defendant than to just some random person. You put a number like that in front of a jury, that sounds like a done deal, absolute certainty.
And the defendant in that case was a man named John Wakefield. Back in 2015, he was convicted of murder, sentenced to life without parole. And the real key to the whole case wasn't an eyewitness or a confession. It was the output of a machine. So the main piece of evidence against Wakefield came from this AI program called True Allyl. It's a really sophisticated piece of software that analyzes messy or mixed DNA samples, the kind of stuff that's often just impossible for a human expert to figure out. But here's the thing. Wakefield's lawyers argued, hey, if this algorithm is basically testifying against our client, we should have the right to see how it works. We want to see the source code.
And this is where it gets really sticky. Normally, right, a defense attorney gets to cross-examine a human expert. They can question their process, their judgment, their conclusions. But with True Allyl, the court said, nope. They could only question the scientist who used the software. The algorithm's actual brain, its source code, was kept hidden, protected as a corporate trade secret. Wakefield's team was basically saying, this is nuts. The algorithm is the real witness here, and we're not being allowed to confront it.
And that right there, that's what brings us to the heart of this whole constitutional mess, this Sixth Amendment, the right to confront your accuser.
This quote from Justice Brennan really nails it. This right isn't just about being in the same room and asking a few questions. It's about something much deeper, the fundamental ability to challenge the evidence that's being used to try and take away your freedom.
You know, this all goes back to the Sixth Amendment, which was ratified way back in 1791. It gives every defendant the absolute right to face their accusers. This is a bedrock principle of a fair trial, and it was put there specifically to stop people from being convicted based on secret, anonymous testimony that they could never challenge.
See, the reason this is so important in the US is because our legal system is adversarial. It's not like in parts of Europe where a judge kind of leads the investigation. Here, the idea is that the truth will come out when two opposing sides battle it out in court. And cross-examination, that's not just part of the process, it is the process. It's how you test the evidence.
And the courts have only strengthened this right to a real defense over the years, from the very beginning in 1791, all the way through these huge landmark cases like Powell v. Alabama and the famous Gideon v. Wainwright. The Supreme Court has said again and again that a fair trial means more than just having a lawyer sitting next to you. It means having the actual tools to fight your case.
Which brings us right back to John Wakefield's case, because what we have here is a head-on collision between two incredibly powerful legal ideas.
It's really like that old paradox, what happens when an unstoppable force meets an immovable object? On one side, you have the unstoppable force of the Sixth Amendment, a defendant's absolute right to confront their accuser. And on the other, you have the immovable object of intellectual property law, a company's right to protect its software, its source code as a trade secret. I mean, that's their whole business. Both are totally legitimate rights, but in this situation, they can't both win.
And for John Wakefield, the immovable object won. You can see how his legal battle played out. He appealed all the way up through the New York courts. At one point, a judge even wrote an opinion agreeing with him, saying the source code should have been made available. But in the end, his conviction was upheld. And in 2022, the U.S. Supreme Court decided not to hear the case, which means this huge question remains officially unanswered.
So you might be thinking, why should this one case matter so much? Well, because this isn't just about John Wakefield. This is about a much wider crisis, as these automated AI-driven systems become more and more common in our justice system.
Yeah, this problem is definitely spreading. It's not just about super complex DNA software anymore. We're seeing the same issues pop up with facial recognition, with predictive policing tools,
even with algorithms that suggest prison sentences. And that brings us to the case of Randall Reed. Randall Reed's story is it's a terrifying look at what's at stake here. He was arrested because a facial recognition program made a mistake and said he was a wanted man. The thing is, he had never even been to Louisiana where the crime took place. He spent almost a whole week locked up in jail before the authorities finally admitted the algorithm got it wrong. Now, just imagine if his case had gone to trial. He would have been in the exact same impossible position as John Wakefield. And, there's another huge piece to this puzzle. Let's say, just for a minute, that defendants did have the right to get the source code. Who's going to pay for the experts to analyze it? Our public defense system is already completely overwhelmed. Look at these numbers. National standards say a public defender shouldn't handle more than 150 felony cases a year. But in a place like Fresno, California, they were handling over 400. The idea that they could also mount a super complex, incredibly expensive, high-tech challenge to a secret algorithm, it's just not realistic. This chart really tells the whole story, doesn't it? Out of about $200 billion that state and local governments spend on the criminal justice system, only around $5 billion, that's just 2.5%, goes to public defense. The playing field is already fundamentally tilted, long before an AI even enters the courtroom. So, at the end of the day, we're left with this: justice, hanging in the balance, stuck somewhere between our most fundamental constitutional rights and the unstoppable march of technology. And look, even the courts know that we are in totally new territory here. This quote, it's actually from one of the court opinions in Wakefield's case. It basically says, the legal system itself is struggling to figure out how to make these centuries-old rights work in a world of 21st century science. And that leaves us with one last massive question. When the most important evidence against you comes out of a secret black box, when your accuser is an algorithm whose thoughts you're not allowed to see, can you really say you've confronted the witness against you? In this new age of AI, we're all going to have to figure out what a fair trial truly means.